Live from the TV30 studio, here is Jim Schneider.
Well, good evening and welcome to inFocus. We're so glad that you've joined us tonight as we talk about public policy issues and talk about a number of matters here on the inFocus program week after week. As we're doing this program live here on January 23rd, we are just 4 weeks away from a very important primary all across the state of Wisconsin. We talk about our spring elections, and right away many people think about April. Well, indeed, April is the final vote that will happen, but prior to that, we have a primary that's going to be held. This year, it is on February 21st, a Tuesday, and it's critically important for you to be informed as to what is on your ballot and the matters that surround the primary itself. The issues on the ballot are going to vary from jurisdiction to jurisdiction. Some of you may be voting on some school board primary issues. Some people in the city of Milwaukee are voting on aldermen in a particular district that is not represented at this particular time. And some of you may have referenda questions that will appear. But there's one common race that's on everybody's ballot, and that is for Wisconsin Supreme Court Justice. Now, friends, even if that is the only issue on your ballot, it is critically important for you to know, to be informed on the candidates, and to be at the polls and cast your vote. But there's a wonderful tool that our state has, and it is a website entitled myvote.wi.gov. myvote.wi.gov. You can go to that website, and at the top of the page there, you'll see a blue button that says, "What's on my ballot?" You click on that little button, and you'll be able to put in your address in the right-hand column there, and you just put in your home address, and you hit the enter button there, and you'll be able to find out what's on your ballot. And that's the best way to know the information, and we'd encourage you to use that state tool to know what's on your ballot here for the February primary, and then start doing research on the candidates that you see there. You'll find names that you perhaps have never seen before, and especially as it relates to a variety of races, but we'd encourage you to use that website to be informed and to cast a prayerful vote when you go to the polls. Well, with us tonight is a candidate for the Wisconsin Supreme Court. We have with us on inFocus Justice Daniel Kelly, former Associate Justice on the court. And Justice Kelly, good to have you with us tonight.
Thanks so much, Jim. It's great to be here.
You had served some time on the court, but there are those who don't know who you are, and so I'm going to have you begin by sharing some information about yourself. I'd like to know a little bit about your family, a little bit about your education, as well as your professional background.
Sure. Well, perhaps we could start with this. My arrival in Wisconsin, back when I was an 18-year-old young man. So I came out here to study at Carroll College in western Waukesha County. Mm-hmm. And, I'd been born in Santa Barbara, did most of my growing-up years just west of Denver. But we didn't have much when we were growing up. And so if I was going to be able to go to college, it was going to be based on what I could save and the financial aid that I could get from school. Well, one day, a recruiter from Carroll College came out to Denver, called me up and said, "I want to talk with you." So we sat down. She laid out what I thought would be a good educational opportunity. And then she said, "This is what we can do for you financially." And I looked at that and I thought, wow, I could actually afford to go to school. So I came out here, had never been here before, didn't know a soul. But the funny thing is, Jim, I fell in love with Wisconsinites the very first day I got here because of the very first people I met. So the recruiter had told me that there was some good fishing in Wisconsin. Turns out that's really true. And I love fishing. So I came out a little bit early so I could do some fishing before studies got underway. Mm-hmm. So I found myself at a park next to a lake, and it's a beautiful weekend. The rest of Wisconsin thought so too, because they were all there, and it was just crowded. So through one thing and another, I ended up sharing a campsite with a young family from Sheboygan Falls, and they were just remarkable. So they were warm and engaging. They just kind of wrapped me in. They invited me to their campfire, shared dinner with me, took me sailing the next day. They basically spent a long weekend teaching me what it is to be a Wisconsinite. And I came away from that experience thinking that I had just met, clearly, the most generous and warm people in the entire state. And they certainly were remarkable, but I found out they were not unique. And so I learned shortly enough that The people of Wisconsin are like that all over. And I learned that they're the people of the open hand and generous heart. So I was impressed enough that I met a lovely young lady at a InterVarsity Christian Fellowship meeting at Carroll one evening, and we got married after my first year of law school. Now, 33 years later and 5 children, she and my children are just my treasures. And I still find Wisconsinites to be the same that they were when I met them 40 years ago.
Wonderful. So education, further education, as well as professional background.
Yeah, so bachelor's degree from Carroll College in political science and Spanish, and then law degree from Regent University down in Virginia Beach, Virginia. And I've spent most of my career in litigation. So most of that was at one of the state's largest law firms, where I went as a young lawyer and learned to be an effective commercial litigator. And I so much appreciate all the people that I worked with there who were mentors to me and taught me really how to be a good lawyer. And then I was appointed to the Wisconsin Supreme Court in 2016 by Governor Walker and served there until 2020. And since then, I've been doing consulting work and writing.
What's been your most, when you look at your time back on the bench at the Wisconsin Supreme Court, what was most rewarding to you about being on the bench?
I'll put it in terms of a very good friend. As I was going through the appointment process, he said, "Now, Dan, are you sure you want to do this?" And I said, "Well, I think so. Why do you ask?" And he said, "Well, you got to understand, your days are going to be spent in chambers, alone, reading, researching, writing." I'm like, yeah. I thought that was just the best. So I don't know if you know, but I'm a bit of an introvert. And so time spent alone is where I get my energy. And the idea of spending my days in chambers, reading and researching and writing, just a joy. So I think those were, and then the oral arguments, when we heard those, the fascinating conversations we would have with the advocates, both instructive and interesting. So hard to single one thing out. I loved the whole package.
You wrote a number of opinions on the bench. And is there anything that stands out in your mind that you wrote an opinion and you just came away with that great feeling of satisfaction?
Yeah, so I'm reminded of something that George Will once said. He was asked if he enjoys writing, and he paused for a moment and he said, "I enjoy having written," which is not quite the same thing as enjoying writing. And I take his meaning on that. Writing's difficult. And I found that, Justice Scalia had very instructive things to say about this as well. Someone once asked him in a meeting that I was at if he found it easy to write because he wrote so beautifully. And he said, "I find writing to be painful." He says, "Sometimes I obsess over the choice of a single word." So it is a difficult process because what you're trying to do is explain the law clearly, persuasively, in a way that is accessible to those who will be relying on that opinion, whether it's the bench, the bar, or the people of our country, or in my case, the people of Wisconsin. And so every opinion I wrote came with its own unique little bit of pain in writing it. However, there are a couple of that I think reflect my judicial philosophy well. And so I would point, I think, mostly to Tetra Tech versus Department of Revenue. Now, this is an opinion that only those who love the law would get really excited about. But it was a question of constitutional law, and it was about whether an executive branch agency had the authority to determine what the law means rather than the courts. So we had developed in Wisconsin a habit over 100 years of deferring to the executive agency's conclusions of law. So they would come into court and they'd say, "Well, here's what we think the law means." The person on the other side of the courtroom would say, "Well, we dispute that." And then the agency would tell the court, well, you have to agree with us. You're supposed to defer to us. And for a very long time, the court did. So we got to Tetra Tech, and we looked at that, and we said, well, you know, deciding what the law means sounds an awful lot like what the court is supposed to do. So we went and we researched the original public meaning of the constitutional terms, and we came to the conclusion that, yes, indeed, it is the court's responsibility to decide questions of law, not the executive agencies. And so I wrote an opinion that turned out to be over 80 pages long. But in my defense, we had almost 100 years of cases to address and why we were overruling those so that we could go back to faithfulness to the Constitution.
Daniel Kelly with us here this evening on inFocus. We're talking about his bid for the Wisconsin Supreme Court. And speaking of which, it was 2 years ago at this time that your name was on the ballot. It was the same day as the same ballot as the presidential preference primary. And you did not advance off that ballot the spring 2 years ago. Why do you want to return to the court?
Sure. So I think it's two parts to that answer. The first, we've touched on a little bit already. Serving on the Supreme Court as one of the Wisconsin's Supreme Court justices was just the honor of a lifetime and a joy. And part of the reason it was a joy is because I understand that all the authority that I exercised on the Supreme Court was borrowed from the people of Wisconsin. And that made them my boss. And I had the greatest bosses a guy could ask for. So that's one part of it. The other part is I've been traveling around the state over the last, well, I'll call it a year and a half or so, and talking with people about the proper role and function of the judiciary within a constitutional construct. And one of the things that I've heard consistently wherever I go is that they want their next Supreme Court justice to have a proven public record of constitutional conservatism. They don't want to take a gamble on who's going to be sitting in that seat next time. And so they're looking for a record that they can point to and say, well, I can be confident that this candidate will be faithful to the Constitution because I can see this record that stretches over a long period of time in which he has been faithful to the Constitution. Because the best indication of what you will do is what you have done. So, and they looked at me and they said, that's you. We see that in you, and we want you to run. And so after a lot of prayerful consideration with my wife and my family, consulting with our 3 a.m. friends, we made the decision to run.
You, on your site, refer to yourself as a constitutional conservative. And so that launches into your judicial philosophy. So comment, what does that mean, a constitutional conservative?
Yeah. So I think it starts with the words in the phrase. So constitutional conservatism is about conserving the original public meaning of the Constitution. So there are really two different schools of thought when it comes to what courts do. One of those schools is what I've just described. You just apply the law as it's written without incorporating your personal beliefs or your personal politics. The other judicial philosophy says, well, the law is the starting point. But you know, you got to understand, the Constitution was written a long time ago. And society today is not what society was then. And the court needs to update the Constitution. So they start incorporating their personal beliefs and their personal opinions about what the law ought to be. And we generally refer to that as activism. So the opposite of activism is constitutional conservatism.
Very fine. On your website, you state that you will prevent judicial activism. How will you do that?
Yeah. So through rigorous scholarship and research and conversations with colleagues and being persuasive when it gets right down to it, right? So on the bench, we call the court a collegial court. Because there is more than one member, and that makes it by definition a collegial court. But also in the more colloquial term, the members of the court need to be able to interact together well. And so when I went to the court, it was my commitment to walk humbly, to love unconditionally, and speak the soft word that turns away wrath. And what I discovered is that I could have just outstanding conversations with any member of the court. And as long as you do that, people will listen because you start with listening to them and respecting them. And so with that kind of an approach, I think that's how you really get the work of the court done. And then it's just a matter of personal presence. So one of the other premier constitutional conservatives in our judiciary is Justice Rebecca Bradley. And so having the both of us working on these issues from a constitutional conservative perspective, I think really strengthens that voice on the court.
Now, you kind of referred to this earlier, but I just want you to explain further on this. There are those who said, well, listen, this is now 2023. We need to get on with the times.
Yeah.
Does our Constitution change as time goes by?
The Constitution has changed over time, but not at the hands of the court, or at least it's not supposed to. So our United States Constitution and our Wisconsin Constitution both have provisions by which, if it really does get out of step with where society is at, and we need to update it, it tells us how to do that. And so there is a provision that controls how the constitutions get amended. And I've looked really carefully at them, Jim, and I don't see anywhere that the court has anything to do with that process. So that is left to the people and their legislature, and that is it. So anytime a court starts telling you, or a jurist starts telling you, that the Constitution needs to be updated and that they're going to do that on the court, what they're telling you is that they're going to violate their oath of office, they're going to violate the terms of the Constitution, they're going to break faith with the people of Wisconsin, and they're going to start legislating from the bench. It is chaos when a jurist starts doing that.
We're going to hit a number of issues here this evening as well. June 24th, 2022, the U.S. Supreme Court released their decision, Dobbs versus Jackson Women's Health. Do you agree with that decision?
Well, whether I agree with it or not, it is the law of the land, and they said these questions will now be dealt with at the state level. And so here we are at the state level, and the question is going to be, what is the process for addressing that? And I hear a lot about this in this campaign. One of my opponents has been very vociferous about what she would do with respect to that issue. And she says, she admits that she's going to disregard the Constitution and our laws. So, we oftentimes, when we talk about the work of the court, we metaphorically speak in terms of the scales of justice, right? And we're supposed to hold them straight, true, and even. And in a recent interview, she said, well, I will, in the vast bulk of cases, I won't put my thumb on the scale. The vast bulk of cases, a jurist has no business at all putting their thumb on the scale, but she has committed herself on this specific issue to putting her thumb on the scale. Now, the proper role of the court with respect to that issue is the exact same role as it is with every other case that comes before the court. We look at the case, we look at the questions of law that need to be resolved, and we resolve those according to the law as it's already written. And this is what the people of Wisconsin tell me through their Constitution. They tell me, look, we've got one job for you, just one. And we want you to do it well, but it's just this one thing. Decide our cases according to the law as it's already written. Now, we don't want you bothering with whether it's a good law or a bad law, wise or efficacious. We've got an entire branch of government to deal with that. We call it a legislature, right? And so their commandment to us, their sovereign voice, is you just decide questions of law. And we'll allow, they say they'll take care of the politics with the political branch. And so with this issue, same as with every other one that comes before the court, you look at the statutes, you apply those to the extent that they're consistent with the Constitution.
Okay, so with the Dobbs decision, we have that, of course, in total contrast to Roe. That happened in 1973. So the justices on the U.S. Supreme Court indicated we're reversing the Roe decision.
Yeah.
If you're in the court here at Wisconsin Supreme Court under a Roe decision versus a Dobbs decision, do you honor either or, depending upon how the highest court has ruled?
Yeah, so Article 6 of the United States Constitution says that the United States Constitution, the laws passed pursuant thereto, are the supreme law of the land. And it went on to say, by the way, state judges, that binds you too. And so when we look at the United States Supreme Court's decisions, when they make an authoritative ruling in a case, that binds state justices, whether we like it or not, whether we agree that they got it right or not. That is something that you are bound to follow. So if you're on the Supreme Court and you're addressing a question in the pre-Dobbs era, you have to follow the Roe decision. Now, after Dobbs, and all Dobbs did was to say that this question is now going to be resolved at the state level.
Right.
It didn't tell the states how to resolve it.
Right.
It just says, you states, each of you work on this. And so now, if you are on the Supreme Court and that kind of issue comes to the court, then the responsibility of a Supreme Court justice is going to be to look at the arguments made by the parties. So I understand that there is a pending case on the 1849 abortion law right now. And interestingly enough, it was brought by Attorney General Josh Call. And in that case, he's not claiming that the law is unconstitutional. He's just saying it's been superseded by a later statute that addresses the same question. So when that gets to the court, if it comes in the same basic context in which it is pending now, the question will be, well, what are the rules on when one statute implies by implication an earlier statute? But the constitutionality has not yet been put in question. Now, I assume at some point it probably will, and that would work its way up to the Supreme Court. And at that point, the question will be, is that statute consistent with or repugnant to the Wisconsin Constitution? And then you'd have to make that decision.
Okay, and I know you cannot share how you would rule on such a case, but that's the thought process you would be going through. Should, and I should more likely say when, that issue makes its way up to the Wisconsin Supreme Court.
That's right.
The Honorable Dan Kelly with us here this evening, running for the Wisconsin Supreme Court. How does your faith impact who you are, and how does your faith impact how you would make decisions from the bench? Yeah, so it has a profound impact on who I am. You know, when you understand that you are a sinner saved by grace, perhaps the first thing that teaches you is profound gratitude. So when I became a Christian, when it became real for me personally, my parents raised me to love God, but I never really experienced that on a personal level until I was 21. So I made a personal profession of faith when I was in college. Not necessarily the normal pathway, but for me, that's what it was. And when that occurred, just the sense of gratitude that I experienced at that point was just overwhelming. I came to learn later that this is kind of the consequence of experiencing grace, unmerited favor, and knowing that my sins had been paid for by someone else, by Jesus Christ, and that I didn't have to carry that weight with me anymore, and I didn't have to have that separation from God anymore. It was just profound. So what that does really is it causes you to go back and question all of your assumptions that you might have had in life up to that point. And so it has been a continuing experience of figuring out what that relationship with God is like, and how that leads and guides, and leading us to eventually reunion with Him. Then as far as the way that it affects the work of the court, I would say this. This is where I get when I mentioned how I deal with colleagues. So it really is about walking humbly. It's about loving unconditionally and speaking the soft word that turns away wrath. And I've learned over the years that when you approach people in humbleness and in love, with a listening mind and with considered words, that number one, you can have a very good relationship with them, built on love and respect. And the natural response to that is that you can actually work together well, even when you're dealing with really contentious issues. Because, as it turns out, on the Supreme Court, you only take the most difficult cases.
and they oftentimes turn out to be very contentious.
Right.
And so, having that as an understanding of how we relate to the rest of God's creation and the rest of His children, I think is exceedingly important to me because that served as the foundation of all the work that I did with my colleagues.
Yesterday, I don't know if you've seen the newspaper or not, the Milwaukee Journal-Sentinel, but I'm going to read a paragraph. They do a little bit of analysis of each of the four candidates running for office, and this is what they said about Daniel Kelly.
All right, let's have it.
They said, while on the court, Kelly wrote a decision that found that Madison could not bar guns on its buses, argued the U.S. Supreme Court decision legalizing same-sex marriage undermined democracy, compared abortion to murder, and praised a decision that upheld Act 10, the 2011 law that scaled back collective bargaining for public workers. It seems to me that the editorials here wanted to, put a screw in you or something here. But how do you respond to this? Is that a fair assessment of who Daniel Kelly is?
Well, I think there is a considerable amount of elision in that description, and what they're trying to make it sound like is that those were kinds of positions that I would take on the court. So they start with the Wisconsin Carey case that I authored, and then they build in various things that they have characterized over the years, and I would not say that they are necessarily accurate characterizations. But I get, what they're trying to do. They've got an agenda that they're trying to promote, and so they're not going to be particularly careful about what they say. So let's address Wisconsin Carey. Interestingly, they are apparently using that as something that is an unusual thing, the conclusion in Wisconsin Carey. And I find that to be not unusual at all. Not a hard case, actually, one of the easier cases that came to the Wisconsin Supreme Court. And the question was whether the city of Madison could disregard a state statute because they thought they had a better way of dealing with concealed weapons. And the answer to that is found in our statutes. So the state statute that they were disregarding said that municipalities may not regulate the carrying of concealed weapons any more stringently than a state statute. Well, state statutes allow for concealed carry, and the city of Madison said no carry under certain circumstances. And obviously that's more stringent, and so we set that aside. So I generally don't respond to media's characterizations of what I've said off the bench when I was not serving as a justice. Now, when I run for the seat, when I serve in the seat, I'm very careful not to comment on political matters because it is incumbent on the judiciary to not only be impartial, but to project impartiality in appearance as well. And so I simply don't respond to those kinds of characterizations.
Last week in the Wisconsin Supreme Court, there were oral arguments. Matter of fact, it was 1 week ago today, in a case known as Alan Gall versus Aurora Healthcare Incorporated. This is regarding an issue of patient rights. It's an issue of the authority a person with healthcare power of attorney has over medical procedures or lack thereof in a kind of medical facility. And I know you cannot tell us again how you would rule on this case, but tell us what the justices who are currently serving on the bench, what should they be taking into consideration as they look at this case itself?
Yeah, so there's a lot of moving parts in that case. So some of the things that they'll have to consider will be, one, the scope of the medical power of attorney. So that's a document that controls when another person can make medical decisions on a patient's behalf. They'll also have to consider the relationship between the hospital and the patient and what rights you retain or don't retain in that relationship. They also have to consider the rights of the doctor in his responsibilities to practice medicine responsibly, and then the personal desires of the patient as expressed through their medical power of attorney. And so those are the pieces that are kind of moving in that puzzle. They're going to have to figure out how to put all those together.
Any indication as to your view on that case?
Not even a little bit.
Not even a little bit. When should a justice recuse themselves from a case?
Justice should recuse himself when, after looking at the circumstances of the case and perhaps whatever the cause is for the potential recusal, personal relationship, a special connection with the issue, something like that, that they conclude that they cannot, both in fact and in appearance, decide a case without reference to personal opinions or personal inclinations. So the objective, part of the responsibility of a Supreme Court justice, let's start there, is to sit on every case he can possibly sit on. That's his duty. That's his responsibility. And that is only relieved when the circumstances suggest that he would not be able to do that consistently with the constitutional command to decide the case according to the law and the law alone. Now that's a decision that each justice has to make on his or her own, because it really isn't impossible to develop a comprehensive rule that would control every possible circumstance that would come before the court and dictate, in this circumstance you have to recuse, and those you don't. So that necessarily has to be left up to the individual justices. But that counsels in favor of being really careful about who you elect to that position, because you want someone who's going to have the character that will recognize when that could be a problem, and then on that basis decide to step back from that case. So this goes to part of the responsibility of our fellow Wisconsinites. So as I mentioned before, all of this authority to create and maintain governments belongs to the people of Wisconsin. And as a Spider-Man movie might say, with great power comes great responsibility, right? So Wisconsinites are responsible for exercising that power in a way that brings people of good character to those positions, so that they will respond to circumstances in the way that will do credit to the court and to the people of Wisconsin.
February 21st is the upcoming primary.
It is.
There are 3 opponents that you have, so there are 4 candidates in all.
Yep.
Only 2 will advance to the April 4th general election. What would you say are the primary issues of separation between you and the other candidates? What separates you the most?
Sure. So I guess we could start with the Dane County Circuit Court judge and the Milwaukee County Circuit Court judge. We talked a little bit before about the 2 basic schools of thought about what a court is supposed to do. So Milwaukee and Dane County Circuit Court judges, they're both on the side that you should be able to bring in your personal politics, your personal preferences, and use those to help you decide cases. So that definitively separates me from them. The third opponent, the Waukesha County Circuit Court judge, is campaigning as a judicial conservative. And so what would separate me from her is that I have a very long public record as a constitutional conservative. So when Governor Walker appointed me to the Supreme Court in 2016, I was already a well-known constitutional conservative and had been for 15 years prior to that. So it's the writings both on and off the court. So, we've touched on a few of my opinions, but I've written several landmark opinions on constitutional issues. The body of my work has been cited, quoted, or relied upon hundreds of times by courts here in Wisconsin and even across the country. And then off the court, I was asked to write a manual on legislative oversight. And if any of your listeners or viewers are interested in having a hard time sleeping at night, they could profitably pick that up, and it should put them out pretty quickly. But in that manual, I described in detail the type of authority that Wisconsinites lent to each of the branches of government and why it's so very important that they not poach on the powers granted to the other branches. And so that sets me apart. I've traveled the state of Wisconsin, and I've given over 100 lectures on the proper role and function of a court within a constitutional structure. So I think that sets me apart. And then finally, I'd say we have really 2 preeminent constitutional conservatives in our judiciary today, Justice Rebecca Bradley, Judge Shelley Grogan, and they both endorse me. And I think the reason they endorsed me is important. So they looked at each of the 4 candidates, looked carefully at their records, and their conclusion is that I am the only constitutional conservative in the race.
One of your opponents has referred to the election maps as being rigged.
Yes, she did.
Do you agree or disagree?
So my personal views on whether it's rigged or not are entirely irrelevant. And this is one of the things that separates her so distinctly from me. So when she says that, and she went on, she wasn't done describing it. She said they're unfair, unrepresentative, and need to be fixed. So what she's saying when she says those types of things, she's declaring her independence from the Constitution and the rule of law. And she's telling everybody in Wisconsin that if she's elected to the Supreme Court, she's going to engage in political decision-making, not legal decision-making. So a redistricting map, as you probably know, it's largely an entirely a political exercise. So what communities to put together, which to separate, where to draw the lines, how to draw them. These are all political decisions, which is why the legislature is supposed to draw the map. So if that comes to the court, then the responsibility of the court is the same as in every other case. It is to resolve legal questions, not political questions. And so, we look at, are the populations of the districts equal? That's a legal requirement. Are the districts compact and contiguous? That's a legal requirement imposed by our Wisconsin Constitution. Then there's the Voting Rights Act. Do the districts as drawn unlawfully discriminate against racial minorities? That's a legal standard. So the court's responsibility is to only address those legal questions. Janet's thoughts on whether it's politically rigged or not are completely irrelevant, or at least they're supposed to be if you're going to do the job of a court. But what she's telling us is she's going to do the job of the legislature in the courts.
You mentioned a couple of endorsements that you have right now. Who else is endorsing you?
A vast array of folks. So there are a number of organizations around the state who want the constitutional order to be followed. So they want, and they've got specific issues that they care a lot about. And what they tell me is that they want those issues to be dealt with the way the Constitution provides. So they want the political issues to be decided by the legislature. They want the legal questions to be decided by the courts. And so some of those organizations who are just absolutely adamant about that include Pro-Life Wisconsin, Wisconsin Right to Life, and Wisconsin Family Action. Each of them has endorsed me because in my conversations with them, they've asked me, what would you do as a justice? How would you approach the work of the court? And I told them the same thing I told you, same thing I tell everybody else in Wisconsin. I will follow the Constitution and the statutes, and I will allow nothing else to interfere with those controlling authorities. And on that basis, they said, that's the kind of justice we want.
You have a website that our viewers can go to?
We do, justicedanielkelly.com. I understand that we're supposed to repeat that 3 times. So justicedanielkelly.com. One more time, it is, it's right there on the screen, justicedanielkelly.com.
Very fine. Well, friends, we'd like to give you opportunity tonight to also ask questions of our guest. Daniel Kelly running for a 10-year term to the Wisconsin Supreme Court, seeking to return to the court. And so we're opening our phone lines this evening to give you opportunity to ask a question that you may have. Perhaps something that the Honorable Justice Dan Kelly shared this evening is something that you want to question him further on. Pick up your phone, give us a call, 414-935-3030. That's 414-935-3030. Toll free. You can reach us at 1-800-733-8830. That's 800-733-8830. And you may also text in a question tonight at this text-in number, 414-439-3585. That's 414-439-3585. So we welcome your phone calls here tonight. And folks, again, this is a very significant race for the Wisconsin Supreme Court, for us as a whole across the state. If you consider the laws that have been passed in our state, There will be a number of challenges that will come to such things as the 1849 law that says that abortion cannot be done except to save the life of a mother. That will be no doubt coming before the court. Act 10, no doubt, will come before the court once again, and numerous other issues as well. So tonight our phone lines are open, 414-935-3030, toll-free 1-800-733-8830. And then also the text-in line. You can text in your question tonight at 414-439-3585. Let me ask you this. If people heard what you had to say here during this first half hour or so, and if you would say, folks, you can forget everything I said here tonight except this one thing, what would that one thing be?
I think it would have to be that the people of Wisconsin have made a sovereign decision to ask their courts to do only one thing, to decide cases according to the law as it's already written. And if you look at my record on the courts, after the court, before the court, everything there speaks to my commitment to the constitutional order and respecting that sovereign command that the people of Wisconsin have made.
There's a text-in question that came from Washington County this evening. It said, could you please explain why legislators, not Wisconsin voters, will be deciding what happens in the state regarding the abortion ban? That's regarding Wisconsin's 1849 law, which banned abortion. In other words, why is it a state constitutional issue?
So the way our Constitution is written, all political decisions are made in the legislative branch, right? So that's where we decide what our public policy is going to be. And this kind of goes back to what I was saying earlier about with great power comes great responsibility. So the people of Wisconsin are responsible for selecting carefully their legislators, because as our Constitution has been written, the legislature is the lead branch of government. And so that's where the people of Wisconsin go to say, look, we are going to loan to you our authority to make law, and we're going to give you the parameters in which you do that. Now, they go to Madison, and then they make that law. Now, we don't have direct legislation in the state of Wisconsin. So we need to make sure that whoever we send to the legislature is, one, going to have an appreciation for the Constitution, and two, is going to be responsive to the people who elected them. And so that's why this question is decided in the, at least as a matter of first instance, in the political branch. And then if there's any concern about that decision violating a constitutional provision, that can then come over to the court, and the court will address that alleged violation of the Constitution.
Mm-hmm. Is anything fair game to come before the Wisconsin Supreme Court? Every law that's been passed in years gone by, fair game for the court?
Yeah, so this is one of the reasons I think it's important that we carefully consider who we send to the Supreme Court. There is no question that could not conceivably come back to the court, even if it's been there before, even if it's been decided there before. There is one of the criteria for accepting a case for review at the Supreme Court is that circumstances have changed sufficiently since the prior opinion was issued that it bears revisiting that question. Mm-hmm. And so as part of our criterion for accepting cases, that is one reason to come back and address a question again. So really anything's fair game to come back.
Wow. Tonight, our phone lines are open, friends. We'd like to take your phone calls, questions that you would have for our guest, Daniel Kelly, as he's running for a 10-year term to the Wisconsin Supreme Court. Again, the number, 414-935-3030. 414-935-3030. Or you can reach us at 1-800-733-8830. That's 1-800-733-8830. And the text-in number as well tonight, 414-439-3585. 414-439-3585. As you look through Supreme Court history here in the state of Wisconsin and or that of the U.S. Supreme Court, is there any case you would look back and say that was wrongly decided?
Yeah, one of the easy ones we go to because it is so illustrative of what the responsibility of the court is. We look back at Plessy versus Ferguson, right? We remember a Supreme Court of the United States saying that separate but equal on racial grounds is constitutionally permissible. And then that case was eventually overruled by Brown versus Board of Education over 50 years later. And the question is, so what is the relationship between prior opinions and later opinions, and when do you overrule and when do you follow? And the way to look at it, I think, Justice Clarence Thomas has been just clarion clear about this. He says, as a jurist, you have to understand that the Constitution comes above everything. So it comes above Supreme Court opinions. So if you eventually figure out that you've made a mistake, the responsibility of a jurist is not to propagate that mistake, it's to correct it. So in Brown, they looked at Plessy and they said, well, it turns out that was wrong. And they were right about that. Plessy was wrong the day it was decided. It was wrong every day after that. And the Supreme Court finally recognized that in Brown. Now, the key is not that Brown didn't change the law. The Supreme Court did not update the Constitution, did not update the laws. It was applying the same Constitution that existed back when Plessy was decided. They simply recognized they'd made a profound mistake. And so they said, our first responsibility is to the Constitution. And so they fixed that, and in the process overruled that erroneous decision. And so, that is, I think, a good description of the fact, one, that mistakes happen, two, that a responsibility of the justice is that when that mistake comes to light, your job is to fix it.
Very interesting. Act 10, this came before the court previous, did it not?
It did.
More than once?
It came a couple of times.
Okay. And
before I was on the courts.
Okay. And yet, can the same matters that brought it to the court the first time resurface the second time?
They could. All it takes is for someone to challenge it once again, bring a lawsuit in the circuit court, and now what will happen if everybody's doing their job? What will happen? They'll file the lawsuit. The circuit court judge will look at it and say, well, the Wisconsin Supreme Court's already ruled on this, and if they're making the same challenge, they'll say, well, we're going to dismiss this because the Wisconsin Supreme Court has already decided that question. The person would then appeal that to the Court of Appeals, and the Court of Appeals would say, well, the Supreme Court's already ruled on this, so we're going to affirm the circuit court, and then they'd file a petition for review. And that in that petition, what would likely occur is the original plaintiff would say, well, there's been a period of time that has passed since you made this decision in Act 10, and circumstances have indicated that a different result would be appropriate now, or you made a mistake, you need to revisit this. And then all it takes is 3 members of the court to agree to take that up, and now it's before the Supreme Court. And then it would take, of course, 4 members of the Supreme Court to decide differently. But that's why it's important that we have a really careful consideration of who goes to the Supreme Court on April 4th and through the primary on February 21st. So will you have a justice who will look back at the law and correctly compare it to the Constitution and make a conclusion based on that and nothing else? But clearly, there were powerful dissents when this was decided, when the Act 10 came before the court before. And so I think it is not outside the realm of probability that someone will try to bring a lawsuit to bring that to the Supreme Court to get them to change their mind.
Is election integrity a concern of yours?
Always. This is the way that we construct our governments. So we go back to Article 1, Section 1 of our Constitution, and it says that we're all born equally free and independent, that we have certain inherent rights. Amongst these are life, liberty, and pursuit of happiness. And it goes on to say that governments are instituted for the purpose of protecting those rights, obtaining their just powers from the consent of the governed. Now, that's not something that we did just once back in 1848 when we adopted our Constitution. We do that every single time we have an election. So it is of the greatest importance to make sure that we have elections that have integrity, because this is the process by which the people of Wisconsin consent to their representatives to exercise that authority on their behalf.
And a number of issues and challenges have come up, we know, across the country in that very issue as well, election integrity. Friends, we'd like to give you another opportunity here to call in your questions. Daniel Kelly is our guest this evening, 414-935-3030. That's 414-935-3030, toll free at 1-800-733-8830. And the text in line here this evening as well, which is 414-439-3585. We're going to pick up a call here from Kathy in Milwaukee. Hi, Kathy, you're on the air.
Hi, I wanted to ask Justice Kelly, because the one judge, I don't know how to pronounce her name. Well, how can they get away with saying that and not get in trouble for that? I thought that was part of their job. I don't understand why there should be, why there shouldn't be any consequences, I guess. I don't understand why they can get away with saying, well, I'm going to use my political view, not the legislative. Do you get what I mean?
I do indeed.
She's referring to the Dane County Circuit Judge?
Yeah, I think so. I think she's the one with the primarily unpronounceable name, so I'm guessing that's who it is.
Yeah.
Kathy, that's a great question. And in fact, it's a question that my wife oftentimes asks me when she sees a constitutional officer doing something that is outside the authority that granted to them by our fellow Wisconsinites. And my answer to her is always the same, and it might not sound satisfying upon first hearing it, but I think that with a little bit of thought, this is the way it has to be. So the answer is there are consequences to that. There could be some consequences through the Judicial Commission. We have a code of judicial conduct, and that requires that we not talk about what our personal politics are in a way that would suggest how we would resolve any questions. So there is a potential avenue for discipline there. But ultimately, the question of discipline and consequences relies on the people of Wisconsin. So as I mentioned earlier, all of that authority to create governments comes from we the people. And because they are exercising authority on our behalf that we lent to them, that means that we the people are the bosses, right? So they're the bosses of Janet Protasiewicz, whether she's in the circuit court or on the Supreme Court. And the responsibility of the bosses is to make sure that they're doing their jobs. Now, Supreme Court justices have 10-year terms. And that's why it's so very, very important that we're careful about who we send there, because once they're there, it's hard to remove them. I mean, you could do a petition for recall. That is one measure of pulling someone off the Supreme Court if they're not following what the people of Wisconsin have commanded them to do, just decide cases according to the law. But otherwise, when that person comes up for election, that's the opportunity for the people of Wisconsin to say, I see what you've done, and you've not been faithful to the Constitution. You've not been faithful to the people of Wisconsin, so we're going to replace you. So ultimately, that responsibility, it all comes back to we the people.
Thank you, Kathy, for the call.
Thank you very much. Thank you.
Bye-bye. We've got Brad in West Dallas. Hi, Brad, you're on the air.
Hey, Brother Jim. Prior to the 2022 election, everybody's talking about the big red wave coming. It turned out to be a ripple. And I heard one guy that's on your TV show, Sam Rohr. He put it in perspective. He says, yeah, it looks like we're going to win. However, the same thing that was in place in 2020 regarding non-voter integrity, let's put it that way, is still in place. Things have not been fixed. And right now, things still have not been fixed. So I was curious as to what your guest had to say about that and how it's going to affect his chances.
Thank you. Thank you, Brad.
Yeah, thanks, Brad, and thanks for your concern for my chances. Here's the thing: one of the roles that we, the people, can play is serving as election observers. So in every ward, you can go and you can actually watch the conduct of the election. And statutes give the public the right to do that. And I think that's one way in which those who are concerned about the integrity of our elections can take a real step in ensuring that the elections, in fact, are being conducted according to law. They can actually go and watch them being conducted. As far as whether there are different laws that we need in order to ensure election integrity, that's a matter for the legislature to address. And in fact, I mentioned that I've written a manual on legislative oversight for Wisconsin, and that manual teaches the legislature how to conduct oversight investigations and hearings to find out what is happening in the broad world, and in consequence of which, what kind of laws we need to adopt to address the public's concerns. So I think that the legislature has the authority to conduct those investigations and hearings to get to the bottom of the public's concerns, and then take appropriate remedial action should they believe that it's warranted.
Mm-hmm. Brad, we appreciate the call here this evening. Justice Kelly, we appreciate you carving out the time and joining us here this evening on the broadcast.
Well, it's a pleasure to be here with you, Jim. I really appreciate it.
Mm-hmm. JusticeDanielKelly.com is the website to learn more information, JusticeDanielKelly.com. And friends, just a reminder that the primary coming up on February 21st. 4 candidates are on this particular ballot. There may be other issues on your ballot too, but just those who receive the top 2 votes will be able to advance to the April election. And so you can see the primary there and the names that will appear there as well, myvote.wi.gov. We'd encourage you to go to the website, see who the candidates are, and then start researching, looking through their websites. Look at articles and so forth. Look at their press releases that they're putting out from their campaign to learn about the candidates. And as always here at VCY, we encourage you to be informed and to vote prayerfully. Thanks for joining us.